Hello, everyone. Greetings from Porto, Portugal. My name is Vieira dos Santos. I'm a PhD student in the Faculty of Law of University of Porto. My investigation concerns the regulation of crowdfunding and initial coin offerings. So the topic I chose for this video is about the new proposal for a European regulation of markets in crypto assets, also called MiCA. I would like to present you a PowerPoint presentation that I made. While I do so, I would like to thank the European Law Observatory for the kind invitation. It's an honor for me. So here we have the presentation. This new proposal was published by the European Commission on the 24th of September of 2020, jointly with a digital finance strategy and another two proposals. It was called a digital finance package. As you can see here, this communication of the European Commission on this on its website. About the digital finance strategy, one of the documents that was presented here within the digital finance package, this strategy has four main priorities: a digital single market for financial service, a regulatory framework facilitating innovation, a European financial data space to promote data-driven innovation, so open finance, and addressing the risks of digital transformation. So here, the topics that we can sum up with these priorities is that the European Commission wants harmonization, wants to foster innovation, and also wants to protect consumers, and also to promote data and data transmission safely. About the proposals, one of them is MiCA, another one is the DLT pilot regime, so a space for experimentation in distributed ledger technologies within market infrastructures. And the third one is DORA, a regulation for cyber resilience operations in financial entities. About MiCA, I'm going to start to talk about the scope of MiCA. MiCA includes the crypto assets that are out of the financial EU law. So crypto assets that are not qualified as financial instruments, are not qualified as deposits, are not qualified as structured deposits, and are not qualified as securitization. So the scope of MiCA is the crypto assets that are not subject to this regulation until now, or until the entering of force of this proposal. So these crypto assets are included in the taxonomy created. This taxonomy is composed by utility tokens, that are tokens that can be used on the platform as a service or as a good. Asset reference tokens, that the value of the token is referred to the value of different asset, like commodities or like a basket of fiat currencies. E-money tokens, that the value of the token is referred to the value of a fiat currency. And we have significant asset reference tokens and significant e-money tokens that can be qualified as significant because of some of criteria that was defined in MiCA, that established the dimension of what can be a significant asset reference token and what can be a significant e-money token, because of their dimension can cause special risks to the financial stability. And I also included others to say that this taxonomy is not closed, is an open taxonomy that also can include crypto assets that are not included in the categories that I referred. So this regulation lays down uniform rules for the following: transparency and disclosure requirements for the issuance and admission to trading of crypto assets. So here we see included the initial coin offerings and the crypto exchanges. We also can see the authorization and supervision of crypto asset service providers and issuers of asset reference tokens and issuers of electronic money tokens. These crypto asset service providers are very like the service providers of MiFID. This establishes a comparison with the service providers of MiFID because of they have almost the same functions. We can see in MiCA the placing of crypto assets, the custody of crypto assets, the execution of other orders of crypto assets. So we can see an inspiration from MiFID. There are also rules for the operation, organization, and governance of issuers of asset reference tokens, issuers of electronic money tokens, and crypto asset service providers. We also see consumer protection rules for issuance, trading, exchange, and custody of crypto assets, and also measures to prevent market abuse to ensure the integrity of crypto asset markets. So MiCA, as we can see, includes a set of rules that are inspiring in many regulations and directives that are for financial service. Firstly, we can see an inspiration in MiFID because the market in crypto assets it's very similar to the market in financial instruments. So we see a comparison with between these instruments, between financial instruments and crypto assets. And also we can see inspiration in the payment sector laws. We can see that crypto assets also can be used for payment purpose. So the European Commission included here these types of tokens, asset reference tokens and electronic money tokens, as the ones that can have payment purpose and so can be subject to the payment rules. In this way, there was an inspiration in the PST2, the Payment Service Directive, and also in the Electronic Money Directive. So you can see the organization of MiCA. We can see the title 1 is about the subject, the scope, marketing of crypto assets, so about the initial coin offerings. Title 3, title asset reference tokens and electronic money tokens, the ones that have payment purpose, so they have specific titles and specific. In the title 5, authorization and operation conditions for the service providers, the title that is very inspired in MiFID and also in the crowdfunding regulation. This because there was an innovation approach, I think, a fostering innovation approach. So there was a light touch regulation and the rules are not so strict as MiFID. This market is also embryonary, so it makes sense to give some space to this market. There in Title 6 there is rules for the market abuse, Title 7 competent authorities and EBA and ISMA. EBA and ISMA also have an important role in this regulation, especially EBA, that is going to be the regulator for the significant asset reference tokens and significant electronic money tokens because of the cross-border approach that that is needed. And the Title 8 and Title 9 is the ones that are in all regulations, delegated acts, transitional and final provisions. I would like to speak about some critical issues that I find in this proposal and share with you. The first one is about the definition of crypto assets, meaning a digital representation of value or rights which may be transferred in store electronically using DLT or technology. In my opinion, this is a very broad definition that may cause some problems. Of course, the definition doesn't define and doesn't determine the scope of the regulation. MiCA regulation narrows a little bit what it wants to regulate, and MiCA wants to regulate the offers and the negotiation, the admission to trading of crypto assets. So crypto assets that are not or admitted to trading are not subject to the regulation. Even so, this definition has so many broad terms like digital representation of value and the use of DLT, that any electronic document used in DLT can be in this regulation. We can see or festival tickets, music festival tickets, that can be used, that can be subject to the MiCA regulation. As you know, there are public sales of these tickets, and they are going to be considered offers in MiCA. In my opinion, this doesn't make sense. If you sell a ticket and it's not subject to trading in a crypto exchange, it's going to be in the scope of MiCA in the same terms as other tokens that are subject to the admission to trading in crypto exchanges. So I think we are not talking about the same thing and about the same risks. So my opinion is that the only criteria that should be used to be in the scope of MiCA is the admission to trading. If you are not talking about crypto assets in the market, we don't see the same risks as other tokens. So the approach should be almost the same as MiFID. MiFID says that transferable securities are traded in the capital market, and crypto assets that are in MiCA, subject to MiCA, should be the ones that are traded in the market, because those crypto assets are the ones that present risks, to financial risks to the consumers and to the integrity of the market. My second critical issue is about electronic money token. That means a type of crypto asset that the main purpose is to be used as a means of exchange and that purports to maintain a stable value by referring to the value of currency. So my issue here is that it's almost impossible to distinguish between electronic money token and electronic money. And MiCA should have a technological neutral approach to this and exclude electronic money from this regulation, because we already have electronic money directive, EMD. So using ELT is not going to change the nature of these instruments. In this, also the distinction between electronic money token and electronic money is not clear. In in the MiCA, it says that electronic money token may not have a claim, but then MiCA obliges the issuer to present a claim to the buyers of the token. In this sense, of and of his essential elementa is not the existence of the claim, but it is the reference to a fiat currency, as it is electronic money token. So mainly they are the same thing, and they should be treated as the same. In this sense, my opinion is that shouldn't be included in MiCA, and the only tokens that have payment purpose should be asset reference tokens. My third and last critical issue is about the qualification as financial instruments. So as we see before, crypto assets that do not qualify as financial instruments and deposits and structured deposits and securitization are the ones that are in MiCA. I didn't include before the electronic money because it says that an exception where they qualify as electronic money tokens. I think this point B, it's unnecessary, so it shouldn't be here in MiCA. It doesn't provide with any value. About financial instruments that are the main topic, because there are a lot of discussion of which crypto assets are securities and which crypto assets are not securities. It's may be clarified by the European Commission, because there are a lot of member states that treat this issue differently. We don't know what is a and it's going to be treated differently if MiCA doesn't include here the criteria for the distinction that must be objective. So it must include objective criteria related to the right of income, like as we have in shares that provides a right to a profit, or a bond that provides a right to interest. It should be clear. Provides with a right of income, it shouldn't be included in MiCA, and this must be clear in the regulation in order to have an harmonized market. This is one of the main priorities of the European Commission, and if the European Commission wants to be successful in this purpose, in this priority, it must include this distinction in the regulation. It is the main instrument to have. So these were the critical issues that I want to share with you. I think, in conclusion, that MiCA is a very important instrument to have an harmonized market and to prevent the risks of crypto assets, and to also gain with the potentials of crypto assets, so with the that crypto asset can obtain. So even so, I think there are critical issues that the European Commission must address to have a clear regulation and to have legal certainty. Thank you very much. It was an honor to present you with this video. I hope you like it. Thank you.